So, 50 MCQs, weekly test 1 polity questions I will be discussing now. The first question is about, with reference to due process of law, consider the following statements. Due process of law is nothing but, you can remember, like natural justice. Procedure established by the law means rigidly we will be following the procedures. Procedure established by law we had copied from British, due process of law we copied from America. In that way, these are the two things. There is another concept which is called as equality before law. Equality before law means everyone should be equal before the law. Next, fourth concept is there, which is called as equal protection of law. Equal protection of law means whereby equal treatment will be provided if they are equals. Equal treatment will be provided if they are equals. If they are unequal, so obviously there will be unequal treatment. That is called as equal protection of law. Means if reservations we are giving, the reservations we are giving unequally. Why? Because they are unequal, so we are giving reservations unequally. Some section of people are reserved, some section of people are not reserved. If they are reserved, some section of people are more reserved, some section of people are less reserved. So, that comes under equal protection of law. So, 4 concepts are there. One is procedure established by law, other is due process of law, another is equal protection of law, other is called as equality before law. So, in simple words we have to understand this. So, due process of law is nothing but natural justice. Procedure established by law means rigidly following the procedure, very rigidly, whereas equality before law means everyone are equal before the eyes of law, whereas equal protection of law means yes, equality will be provided if they are equal. Equality will not be there if they are unequal. So, unequals will be treated unequally. In this way, 4 concepts are there. So, first one is with reference to due process of law. The first question is, it checks that the law does not deprive life and liberty of a person and the law made is fair, just and not arbitrary. Due process of law. It checks that the law does not deprive life and liberty of a person and the law made is fair, just and not arbitrary. This particular judgment is, or this particular point or this particular statement is the outcome of Menaka Gandhi case. In the Menaka Gandhi case, the Supreme Court told that the law should be the law should not be arbitrary, the law should be fair, the law should be just, everyone should be treated equally. What happened? When Sanjay Gandhi was being booked under emergency provisions, so there was a case against the Sanjay Gandhi. So, she was a wife. When she was travelling out of the country, she was also booked. Then she questioned that if my husband or if any case is been there, then why you are treating me as a criminal? In that particular context, Menaka Gandhi case was came, which tells that it can be executive resolution, it can be a legislative law, everyone should be treated equally. There should not be any unequal treatment. In this way, so due process of law means it checks that the law does not deprive life and liberty, the law does not deprive liberty of person, law should be fair, just as well as arbitrary, no arbitrary. Second point, as compared to procedure established by the law, due process of law has narrow interpretation. Understand this. As compared to procedure established by law, anything which is rigid, anything which is stubborn, we call narrow minded people. Yes. Any person who is rigid, any person who is stubborn means he is not open. Whereas due process of law means natural justice. Natural justice or due process of law means subjected to change. When subjected to change means what? Obviously, it means the interpretation is wider interpretation. So, as compared to procedure established by law, due process of law has narrow interpretation or broader interpretation? Broader interpretation. So, second statement is wrong, first statement is correct. Menaka Gandhi case is related to due process of law. How many of the statements given above are correct? So, in this how many statements are correct? Only 2. So, due process of law, which is nothing but natural justice, which means that it can be a constitutional amendment, it can be a legislative law, it can be executive resolution, it can be a judgment also. It should be fair, just and not arbitrary. Means there should not be any bias, there should be equal treatment to all. So, that particular judgment is called as right to life or right to liberty. The first judgment which told that there should not be any arbitrary rules, under which judgment? Menaka Gandhi case judgment. Answer is B, the same thing. Second question, consider the following statements in the context of Indian Constitution. The term liberty means license to do what one likes. Multiple times we discussed about the terms. In that, liberty is nothing but absence of constraints. absence of constraints is called as liberty. So, what it mentioned here, the term liberty means license to do whatever, no. Answer is, the statement is wrong. The term equality means the absence of special privileges to any section of the society. The term equality means the absence of special privileges to any section of the society. The principle of liberty, equality and fraternity should be treated separately and cannot be unified. So, in this, what is the judgment? The term liberty means license to do what? One, select the incorrect. So, the term liberty means license to do whatever. It is correct or wrong? Wrong. So, 1. The term equality means the absence of special privileges to any section of the society. The term equality means absence of special privileges to any, yes, absence of special privileges means I am seeing everyone equally. Absence of any special provision or privilege for any section means I am not giving privileges to any section. So, obviously, it is called as equality. The principle of liberty, equality and fraternity should be treated separately and cannot be unified. Obviously, they can be unified. Liberty is associated with equality. When there is equality, then there will be universal brotherhood or common brotherhood. So, these three are interrelated concepts only. The question is about these three are interrelated or not. These three are interrelated. But here mentioned it what? Should be treated separately. It should not be treated separately. It should be treated in interrelationship. So, answer is, consider the following statements about the word secular. You know better than me. Secular. Which constitutional amendment added to the preamble secular, socialist and integrity? SSI. Secular, socialist and integrity is added through 42nd Constitutional Amendment Act. What is Indian form of secularism? The Indian form of secularism means state will involve in all the religion. State will involve. What is Western form of secularism? State will not involve in religion. But Indian form of secularism means state will involve in all the forms of religion, but equally, without any discrimination, without any arbitrariness. It is Indian form of secularism. The term was added by 44 or 42. Indian secularism provides for strict separation of state? No. It will allow the state to involve in religion. This is also wrong. This is also wrong. Article 15, 16 and 44 of the Constitution promotes secularism in India. Article 15 talks about what? No discrimination based upon religion, race, caste, sex and place of birth. Article 16 talks about public opportunities. Public opportunities should be provided for all the sections. Religion is also there. Religion is also there. 44 talks about what? Uniform civil code. Means what? There is, irrespective of religion, everyone should be treated equally. So, you tell me whether Article 15, 16 and 44 of the Constitution promote or not. So, answer is only one statement is correct. Why? Because 44 is, yes, 44 is the best example of secularism. If any foreign people ask us, we can write in a mains answer also. Or in UPSC, if someone asks UPSC interview, can you tell me one article which is present in the Constitution which tells indirectly that India is a secular country, apart from 25, 26, 27, 28, 44. Uniform civil code, irrespective of religion, we are going to treat you equally. Only one. Answer is A. Consider the following statements regarding the Indian Independence Act of 1947. Indian Independence Act of 1947. First statement. It abolished the office of Governor General of India and the British monarch's right to veto bill. See, it is not the Governor General of India, it is Viceroy. Viceroy was been abolished. In place of Viceroy, again Governor General were been appointed. And there were been Governor General in Pakistan as well as in India. And Indian Independence Act told that India is Dominion status. Yes or no? Indian Independence Act didn't give complete independence to India. Indian Independence Act didn't give complete republic status to India. What status we got? Dominion status. What is dominion status? Yes, I will be independent. I will be sovereign. But who will be controlling me? The British. The crown of British. So, India is what? Immediately after the independence, according to Indian Independence Act? Dominion status. Not only India, India and Pakistan, both are dominion status. Governor General in the name of His Majesty had full powers to give assent. I told you. Which status we got according to Indian Independence Act? Dominion status. Means after independence also, the Governor General is going to work under the hands of Majesty. You tell me, India is not, after Constitution of India, India is no more dominion. after Constitution of India when it came into force. Another country is there, today also it is a dominion country. Australia, very good. Australia, Canada, they are also today dominion. India was dominion after independence, but immediately it was been removed by the Constitution of India. Pakistan is also not dominion. Governor General in the name of His Majesty had full powers to give assent to the bill. True. Not now, according to this act I am talking. It abolished the office of Secretary of State. Yes, Secretary of State was been abolished by the Indian Independence Act. Select how many statements are correct? 2 and 3. So answer is B. Yes or no? Indian Independence Act. Through which act we got independence? Indian Independence Act. Through which act we got independence? Means it is Indian Independence Act only we got independence. Consider the following statements about the Government of India Act of 1858. The most important, you can write in the mains also. What? Governance, GS2. In any compulsory there will 4 or 5 questions on governance, good governance, e-governance, governance. Compulsory question will be there. You can write historically. Good governance is envisaged not only after independence. Before independence also we have the concept called as good governance, by the name called as good government, by the Government of India Act of 1858. The main agenda of Government of India Act of 1858 is, already we ruled, so people are against us, so they had a revolt on us, which is called a Sipahi revolt or Sipahi mutiny. Now it is a time to provide good government, so that the people will not further revolt on us. So that means what it is giving answer, if we want to suppress or if we want to address the movement, the only solution is good governance. So it is not after independence, before independence only we learn the lessons. How we learn the lessons? By 1858 Sipahi mutiny. How I can tell? By 1858 Government of India Act. In the 1858 Government of India Act, the lessons were been learned from Sipahi mutiny. The same thing. The act introduced system of double government in India. Double government in India is added by what? 1784 Pitt's India Act. 1784 Pitt's India Act came up with 2 bodies. One is called as Board of Control, other is called as Court of Directors. Court of Directors subsumed and came up with an offshoot. Another body came and that body is called as Board of Control. So 2 bodies will be there, which is called as what? Double government. One is Board of Control for political affairs, one is for Court of Directors for commercial. It is not Government of India Act of 1858, it is because of Pitt's India Act of 1784. It created a new office of, it created a new office of Secretary of State, and the Secretary of State will be staying in British. He is one of the cabinet minister and he will be accountable to the British Parliament. And all the affairs of the India will be addressed to the British Parliament through whom? So Secretary of State is directly associated with whom? British Parliament, and is responsible to the affairs of India. What is happening in India, this person is the main person who will be giving information to the, means what? Directly or indirectly, who is controlling India? Secretary of State. So that office created by, so means what? The meaning is the British Parliament started controlling India. By which act? 1858 Government of India. Through whom? Secretary of State. This is wrong. This is correct. The act made the Governor General of Bengal as the Governor General of India. It is 1833, no? Yes. Governor General of Bengal was been renamed as Governor General of India by 1833 Indian Charter Act. So this is also wrong. Select the correct answers given below. What is the correct answer? 2. Yes or no? Answer is B. The same thing is there. Next question. Indian Constitution described as a living document, or we can interpret like this also. Indian Constitution is described as organic document or as a dynamic document. What is called as organic? My body is organic body. What is the beauty of organic? Organic is amendable. It can be amenable. It can be changed. It can be altered according to what? According to time. It can be organic, it can be called as dynamic, it can be called as living. Yes, Indian Constitution is a living document or organic document or a dynamic document. Why? Because Indian Constitution is not rigid. Indian Constitution is a combination of rigidity and flexibility. I am not telling flexibility also. It is a combination or a synthesis of rigidity and flexibility. Executives have more say in amendment of the Constitution. No. Long living tradition of secularism in Indian society is reflected in the Constitution. Indian Constitution allows its amendment in order to adjust itself to the changing conditions and needs. None of those. Answer is, for every 10 questions, 2 questions I gave you one one sentence. Means 20% of the questions are easy and remaining 40% are more than medium and 40% are tough. Categorically based upon the statistics, the questions are being created. So 20% means for every 10 questions, 2 questions are one liner. Means out of 50, 8 questions are one liner. Means out of 100, 16 questions will be one liner. If you check the UPSC also will be the same. And 4 or 5 questions will be more in UPSC only. See. Consider the following statement. First schedule, you tell me now. First schedule of the Constitution talks about what? Union and the states. The name of the country, the name of the states, where it is present? The first schedule of the Constitution. Second schedule of the Constitution talks about?
Privileges, emoluments, pension.
Cheppali. ఊరికే కాదు సినిమా కాదు ఆన్సర్ చెప్పాలి. దిస్ ఇస్ డిస్కషన్ క్లాస్ అందరిని అంటున్నాను. సెకండ్ షెడ్యూల్ privileges, emoluments of what? Not generalized. Second schedule of the Constitution provides for emoluments, allowances and privileges for Prime Minister of India. First statement. Second statement. The third schedule of the Constitution contains the oath and affirmation of the President of India. In third schedule, President of India is not there. Council of Ministers is there. MLAs, MPs are there. MPs are there. Council of Ministers are there and constitutional body members are there. Fourth schedule, how Rajya Sabha members will be elected, Rajya Sabha seats are present in fourth schedule of the Constitution. How many of the statements given above are correct? This is correct. Incorrect. So, this is correct only. How many are incorrect? Tell me. In 3.
1 and 2.
This is incorrect. Second schedule of Indian Constitution provides for what? Yes. President,
Speaker,
Vice President, Prime Minister is also there. Prime Minister is also there. See, the question is not absolute. Only Prime Minister is there, then it is wrong. If it is only Prime Minister, extreme word. If only Prime Minister is there, then it is wrong. Prime Minister is also part of Schedule 2. If only Prime Minister, as you told, it is wrong. Extremes, what we studied in the earlier classes. If it is only Prime Minister, 100% it is wrong only. But it is Prime Minister means not absolute, it is a qualified question. So yes, Prime Minister is also part of it. A box is there, in that ball is there. With that ball, other balls also there. I am telling that ball is present in it. Is it wrong? One box is there, a red color ball is there and other color balls are there. I throw this red color ball into the box. I am telling that this red ball is present in the box. Is it wrong? Red color ball is also present, no? If I tell only red color ball is present, then it is wrong. Red color ball is present. Yes sir, red color ball is present. So answer is, we have to identify extreme word, absolute word. Extreme word is not there. Agar say only hai, then it is. So how many are correct? 2. Means next onwards, when you are doing questions, keep in your mind, I told you earlier also, please identify those extremes. Only, neither, either, none, alone, no, always. So here there is no extreme word. So we have to wait there, we have to check there. So only 2 are correct. Yes or no? Simple logic. A box is there, in that one red ball is there, in that box red ball is there or not? Red ball is there. So answer is correct. Next question. Which of the following? B. Incorrect. Incorrect is B. This provides for emoluments, allowances, privileges for Prime Minister. So answer is, how many are incorrect? Only 1. Yes, this is correction. Yes. Next. Which of the following statements? Please. Which of the following statement? Which of the following judgments case that Indian Constitution is founded on the bedrock of balance between fundamental rights and directive principles of state policy? Answer is, which year? 80. Keshavananda Bharati case, basic stuff. Vaman Rao case, judicial review for constitutional amendment. Kehoto-Holland anti-defection law. Please write down. Keshavananda Bharati case, you know 1973, it is mainly with respect to what? Basic structure doctrine. Minerva Mills case, mainly with respect to 1980, that is a proper balance should be there between the fundamental rights and directive principles of state policy. Vaman Rao case, it is mainly with respect to judicial review will be with constitutional amendment also. Which year? 1981. Next is Kehoto-Holland case, mainly with respect to anti-defection law. Which year? Chronologically also correct. Chronologically also correct. So answer is what? B. Answer is what? B. Minerva Mills case, 1980. Bedrock. Means what, sir? Whether fundamental rights are correct or DPSP are correct. If you ask generally, no, balance should be there. No sir, you tell me who is final means fundamental right only final.
Yes.
Balance should be there. A proper stability will be there, should be there between the both. No sir, you tell me whether fundamental rights or DPSP, it is fundamental rights. Which of the following aims at establishing political democracy in the country? You know, political democracy means fundamental rights, social and economy means DPS. Final. Social and economic means DPSP, political means fundamental rights. The answer is C. See, fundamental rights in the part 3 of the constitution, copied from USA Bill of Rights, is rightly described as Magna Carta of India. Next, consider the following statements regarding the constitutional amendment bill. When it is passed by both the houses of parliament, the president must give the assent to the bill, the president can withhold assent to the bill, the president can return the bill for reconsideration to the parliament, the bill does not require the assent of the president if it is passed with a special majority of the parliament and the ratification of half of the state legislature. The bill does not require the assent of the president. No. Correct. So, this got eliminated. Now, you tell me. First, the president must give the assent to the bill. Consider the following statements regarding the constitutional amendment bill, whether it is required, whether it is compulsory that he should give his assent to the bill. Number 2, the president can return the bill for reconsideration to the parliament. That is constitutional amendment bill. Online. General bill, obviously it can be returned. The constitutional amendment bill passed by both the houses of parliament needs the assent of the president. The president must give his assent to the bill. He can neither withhold his assent to the bill nor return the bill for reconsideration of the parliament. The 24th Constitutional Amendment Act made it obligatory for the president to give his assent to the constitutional amendment bill. So, this particular Constitutional Amendment Act made, if it is a constitutional amendment bill, the president should give his, if it is normal bill, he can give his assent, he can withhold his assent, or he can send it for reconsideration. Withhold his assent is called as pocket. If it is sending for reconsideration, he can send it for but it is a constitutional amendment, it already passed from the people's elected body called as Lok Sabha and elders body called as Rajya Sabha. So, there is no need for recheck from, or if I tell president is an individual, it is not an institution, whereas Lok Sabha and Rajya Sabhas are institutions, and the institutions are greater than the persons. Institutions are greater than the individual. Prime Minister office is greater, not Prime Minister. The Prime Minister is having huge power. It is because of the office called as Prime Minister office, not because of being a election commission of India is the greatest, not the election commissioners. So, it is the institutions which are important rather than the correct Meghala and Bhargavi. Consider the following statement with respect to justice. How many justice are there in our preamble? Social justice, economic justice, political justice. Social justice, economic justice is ensured by DPSP, political justice is ensured by fundamental. Economic justice means the constitution wants to create a society without discrimination on any grounds like caste, creed, gender, religion. That is called as social justice. Social justice means no discrimination can be caused by people on the basis of their wealth, income and economic status. So, both are wrong statements. Correct. Political justice means all the people have an equal, fair, free right without any discrimination to participate in political opportunities. So, how many statements are correct? Which of the following statements? See, one question will be tough, one question will be easy. Don't judge, don't come to a judgment. Justice, just rippling. I know that, rippling. But next, this is important. This concept is important. Leave, you can identify it, but understand the concept. This is a new term which came by the judicial interpretation recently, again. Constitutional punctuality. Like constitutional morality, a new term came which is called as constitutional punctuality. What is constitutional punctuality? With the language also we can come, but remember the concept. It refers to the timely discharge of duties and responsibilities by various constitutional high officers in accordance with the provisions of Indian Constitution. Timely discharge of duties. It means adherence to or being faithful to bottom line principles of constitutional values. It is the idea that government should be limited in its powers and its authority depends on its observations of these limitations. None of the above. What is the answer? What is the answer? What can be the answer? A only. It refers to timely discharge of duties and responsibility by various constitutional high officers in accordance with the provisions of Indian Constitution. I will tell you a classic example. When the Narendra Modi was a Gujarat Chief Minister, he didn't do any mistake with respect to Gujarat riots. He didn't directly give any orders, there is no evidence. He didn't give any orders. But the only problem with him is he didn't follow constitutional punctuality. Means as bearing the office, is the bearer of the office of constitutional high value, which is called as Chief Minister office. He didn't give the order to the police, which he need to give, either to go on lathi charge or shoot at sight orders, which is inevitable on that particular moment. He delayed it for 3 hours. The delay of 3 hours led to, according to Shah Committee report I am telling you, because of the delay of 3 hours giving orders, the Kand happened. The Kand is resulted in the death of nearly 8,000 people and the rape of nearly 300 to 400 women. So, the classic example is what? So, he didn't do any crime. He didn't give any orders. He didn't told to kill also. But what? The duty which he need to do on the time, what was not performed. Hence, it happened. Hence, that concept is called as what? Constitutional punctuality. So, remember this. So, the question can be asked in any format. Constitutional punctuality means the people who are the bearers of the constitutional high values should perform their duties as per the demand. Consider the following statements about Article 30. You know, Article 29, Article 30. Article 29 is what? Protection and preservation of religious minorities and linguistic minorities. Article 30 is what? Right to establish educational institutions for religious minorities and linguistic minorities. Consider the following statements about Article 30, right of minorities to establish and administer educational institutions. Religious and linguistic minorities are provided the right to establish and administer educational institutions of their choice. Correct or wrong? Correct. The right is available to citizens as well as non-citizens. No. See, if it is available for non-citizens, what will happen? Everyone will open it. It provides for establishment of National Commission for Minority Educational Institution. It provides for establishment? No. 1992 National Commission for Minorities was been established like an executive body. Then in 2004 a legislative body was been found which is called as National Commission for Minorities. It is not a constitutional body. If it is true, then this National Commission for Minorities will be called as constitutional body. But National Commission for Minorities is not a constitutional body. National Commission for Human Rights is not a constitutional body. National Commission for Women is not constitutional body. But what bodies these are? Legislative body. Statutory bodies. National Commission for BC is what? Constitutional body. NCSC, NST, NCST are obviously constitutional. National Commission for BC is a constitutional body under which Constitutional Amendment Act? 101 is with respect to GST. Yesterday only we discussed. Then OBC, National Commission for which Constitutional Amendment Act? Options are 101, 102, 103, 99 also, 100 also, 98, 99 also. Tell me now. 103 Constitutional Amendment Act is responsible. Then 102, 101 is GST, 103 is National Commission for BC, then 102. These are not facts, these are concepts only. This you have to remember, I should also remember. Land border dispute. Adjustment of land border dispute between India and Bangladesh. What is answer? Only one. One only. One only. Next. How many of the following rights have been inferred as fundamental rights under Article 21 of the Constitution? See, Article 21 has a wider ambit. Article 21 is a living article, a dynamic article. Every day it is getting, the ambit is increasing with respect to Article 21. Right to sexual orientation comes under Article 21. Right to choose the partner comes under Article 21. Right to choose the partner after marriage. Adultery is also being interpreted by the Supreme Court as Article 21 of the Constitution. It is the right to choose the partner for the bodily pleasure is also called as Article 21 of the Constitution. The ambit of Article 21 is very, very wider. So, what comes under Article 21? Right to livelihood, obviously. Right to privacy under Puttaswamy case. Right to reputation. right to sustainable development, right to travel abroad. This right to travel abroad is Menaka Gandhi case. So how many are correct? All five. Right to reputation also. Everyone have the right to improve their reputation. It is a fundamental right. Consider the following statements about Article 20 of the Constitution. Article 20. It protects a person from being compelled to be witness against himself. Means I cannot be a witness for my own case. Prosecution and punishment for the same offence more than once. Once I got the punishment, again I will not get the punishment. Under Article 20. Then Article 22 क्या है? Preventive detention. It provides for a person who has been arrested right to consult and be defended by a legal practitioner. It comes under Article 21, but Article 20 is, answer is, sorry, which one is wrong? Think once. It protects a person from being compelled to be a witness against himself. It protects a person from prosecution and punishment for the same offence. It provides for a person, incorrect here. Third, incorrect. So how many are? Only one is? It is not correct, it is incorrect one. Leg will fall in sambar if you are not alert. Next. The concept of equality before law, correct only. The concept of equality before law has been taken from the American Constitution, and the concept of equal protection of law is taken from British tradition. Equality, reverse. Equality before law is a negative concept which connotes the absence of any special privileges in favor of any person. Equal protection of law is a positive concept which connotes the equality of treatment under equal circumstances. Means what? This is correct, as I told in the first question. Equality before law means whatever it may be, I am going to treat equally. So negative. Means special privileges means like giving special privileges to SC. Those all will not be there in equality before law. Correct. The concept of equality before law has been taken from British. The concept of equal protection of law is taken from America. This equal protection of law is taken from America, which is a best example of affirmative law. On this basis only, the Indians means tribals in North America, in United States of America, the Indians got reservation under equal protection of law. So this equal protection of the law is the innovation of America. So how many statements are correct? 2 and B. Consider the following statements about Article 15 of the Constitution. Under Article 15, there should not be any discrimination based upon 5 grounds: religion, race, caste, sex, place of birth. And 2 things you have to remember. When you use the word sex in biological context, when you use gender, it is in sociological concept. It provides that states shall not discriminate against any citizens on the ground of religion, on the grounds of race, on the grounds of caste, on the grounds of sex, on the grounds of place of birth. What is not there?
Descent.
Correct only. This is correct or wrong? Wrong. All the provisions mentioned in Article 15 provides the protection against the discrimination by the state only.
No. Private persons as well.
Private persons as well. This is also, again, see, remember, only means you have to stop there. The state is exempted to make special provisions for women and children. True. So answer is 3 only. 17th is C. 18th question. How many of the following statements are correct? We will remember. 25 is what? Right to profess, practice, propagate any religion of choice. PPP, one more is there. Profess, propagate, practice. Anyone is there more? PPP? Profess, practice, propagate. Consensus of their choice. So Article 25, rights provided under 25 of the Indian Constitution available only to the citizens of the India. No. Only citizens of India? No. To non-citizens also. Article, wrong statement. How many are correct? Not only to Indians, means that means when any American is worshipping their God, we are stopping. So it is completely denied. So it is for both citizens and then who are only for Indian citizens? 15, 16, 19, 29, 30. 15, 16, 19, 29, 30. Only for remaining all are for
Non-citizens as well.
non-citizens and
Except enemy agents.
Article 26 provides that no religious instruction shall be provided in any educational institution wholly maintained out of state funds. Which article? Number 28. Article 28 deals with the right to establish and maintain institutions for religious and charitable purposes. 26, 28. Select the correct answers from the given above. How many are correct?
None.
What is 26 then?
Right to maintain.
Maintain, manage the religious affairs. So this is also wrong. What is 28 then? When it is totally funded by state. So this is also wrong. So answer is none of them. D. See here, I made it. The right to freely profess, practice and propagate, have right to establish and maintain institutions for religious and charitable purpose, have right to manage own affairs in the matters of religion. Article 28 of Indian Constitution states that no religious instruction shall be provided in any educational institution wholly maintained out of state funds. Martial law, which article?
34.
34. Article 34. Then what is 33?
Rights with respect to
There will be no rights. There will be no rights mainly for defense.
defense, police force.
There will be no rights for defense police forces. Consider the following statements about martial law. It suspends the government and ordinary law of the courts. Why? Because martial law itself is a martial court. This is correct. There are specific and detailed provisions in the Constitution that authorize executives to declare martial law. No, there is no specific Constitution. See, you have to listen carefully. SCs are not defined. STs are not defined. OBCs are not defined. Minorities are not defined. Religious institutions are not defined. Untouchability is not defined. Why, sir? Tell me why? Why? Because they are intelligence. Why means I will tell you. See, if I fix untouchability means only we should not touch, then the ambit would be so much limited. So untouchability is not only it's about a physical touch. Untouchability can be a feeling also. Untouchability is something which we are creating the situation also. Untouchability is something which is bypassing also. So untouchability can be in any form. That is the reason they didn't define untouchability. Minority they didn't define. Why? Because today Hindus might be majority. But what happened today in Jammu and Kashmir? Who are minorities? Very soon Kerala is going to become for Hindus minorities. Very soon Assam or West Bengal or some states of Northeast also Hindus are going to become minorities. So that is the reason they didn't define minority. Why? Because if they define minority, finished, they are closed. We can change, anyhow Constitutional Amendment Act is there, but it will be closed. There are specific and detailed. No, again specific, extreme word. Specific means only, no. Specific. Imposition of it affects both fundamental rights and center-state relations. It will impact fundamental rights but not center-state relations. Center-state relations will continue, only which will be hampered? Fundamental rights will be hampered. So how many are correct and how many are wrong? Only one. A Canadian citizen staying in India, means a foreigner, cannot claim right to equality before law. No. He can claim equality before law. Protection of life and person. Yes, we have to protect the life and personal liberty. Freedom of trade. No. He doesn't have the freedom. Trade and profession. He cannot tell it's my fundamental right. If he want to do compulsory, he need to take some specific permissions from the government. Then only he will be allowed. There will be lot of limitations for him. If not, it will become another East India Company. If not, there is a chance of another East India Company. For example, common public will think when Bhutan people will come and here, Nepal people they come and they sell their sweaters. They are very, very below poverty line people. But what the locals will think that? The locals will think that these people are coming like business, you people are also coming like East India Company. So one point of time you will also rule us. So they were being beaten by Maharashtra people. Why? Because Marathi means, it's not Marathi, Maharashtrians, it is Shiva Sena, it is Maharashtra Navnirman Sena who are parochial in mindset. So, there you see here in winter season in Delhi we can see the shops of Bhutan, we can see the shops in Hyderabad, we can see the shops in Bangalore, but not in Mumbai. Why? Because in Mumbai, in the Shiva Sena people, they threatened, saying that now you people will come for this and you will not allow us to establish, or you will not, you will hijack us. So, they do not have freedom of trade. Then how they establish, sir? Informally. Then how they establish, sir? Informally. How? Some person will be having the citizenship. Through him, they will come and they will establish. They will manage. Why? Because there is no license. Whether they have license, whether they have any trade license, they will not have any trade license. This is what doing trade means, through what? Trade license. There is need for trade license, not to do trade. Consider the following statements about Article 38 of the Constitution. What is Article 38 of the Constitution? Online. Very good. Article 38 talks about directive principles of state policy are the guidelines, though they are not enforceable. It directs the state to promote the welfare. True. It is a guideline promoting what? Welfare. It provides for equal pay for equal work for both men. Which article? 39. The article has been amended only once by 44th Constitutional Amendment Act. Article 38? No. Yesterday also, some day, 2-3 days back, I discussed this. 38. See, provide the state shall strive to promote the welfare of people by securing and protecting as effectively as it may social order in which justice, social, economic and political shall inform all the situations of the national life. Has been amended only once by 44th Constitutional Amendment Act. It added a directive to minimize the inequalities in income, status, facilities and opportunities. So, minimizing what? Income inequalities. 2-3 to 4 days back we discussed this. So, what is answer? 1 is correct and 3 is correct. 22. Which of the following directive principles are not enshrined in the part 4 of the Constitution? Easy question. Last. Easy question. Claims of the members of SCs and STs to services not enshrined in part 4. To promote education economic interests of SCs, STs and other workers. Which article? 46 or 45? 46. Maintain just and honorable relations between the states. 51. International relations. Maintenance of international relations. Claims of members of SC and ST is not part of it. So, select the correct answers from the options below is to promote international peace and security and maintain just and honorable relations between nations and to foster respect for international law and treaty obligations is liberal intellectual principles are not enshrined, maintain just and honorable relations between nations. A full total. Directive principles of state policy resemble instrument of instructions. Everyone know that. It is 1935. Easy, damn easy question. Government of India Act of 1935. Instrument of instructions. Article 51 of the Constitution of India. The states shall endeavour to promote international peace and security, maintain just and honourable relations between, provide relief to other nations during times of emergency, encourage, provide relief to other nations, whether it is there, no. Encourage settlement of international disputes by arbitration, means peaceful resolution, foster respect for local laws, 1, 2 and 4. DBSP. According to Article 36, what is Article 36? Definition of state. What is Article 12? Definition of state. The state has the same meaning as in part 3 of the Constitution dealing with fundamental rights. How many of the following bodies? Parliament is state, Council of Ministers is state, Public Sector Enterprises is state, Municipal Corporation is state, National Tiger Conservation Authority. This authority is established by statutory act. It is also state. Not only this, any private contract working for the government is also state. Any private employee working for government is also state. With respect to fundamental rights. With respect to directive principles of state policy, only executive resolution bodies, legislative bodies or any body which is established by a judiciary, like what? When Nirbhaya case happened, one member committee was been constituted which is called as Verma committee. Now this Verma committee is working. So if this Verma committee also violates fundamental right, it is called as state. So any body formed by executive resolution like Niti Aayog, it's executive resolution or a law? Executive resolution. Any body which is established by statutory body like what? Right to information body. What is that? It's a statutory body. Third is what? Any body which is established by the judicial body. Sometimes judiciary also will establish the body like committees, like commissions will be established by the judiciary. Then also it is called as state. Why? Because that body is working on behalf of the judiciary mainly to give recommendations to the judiciary and they go. But in that particular point of time, if they violate any human rights or if they violate any fundamental rights, it is seen as state. But it is not called as DPSP or it will not come under part. Here it is what? Fundamental rights. So there is difference between fundamental rights state definition, DPSP state definition. First you tell me, state definition under 12 what all comes? Bodies established by the constitution, bodies established by the legislative body, legislation, the bodies established by executive, the bodies formed by the judiciary on ad hoc basis or permanent basis, private employees working for the central government or state government, contract employees working for central government and state government, any contractor working for the central government or state government. These all are called as state under definition 12. Under definition 36, who constitutes state? Understand, means who are giving guidelines, who are giving care. Who are giving care? Central government bodies, state government bodies, parliamentary bodies, or any public sector undertaking, or any body established by the parliament. Only this will be called as DPSP. Only why? Because guidelines, they are going to give guidelines only. Answer is all 5. No, if the question is
Strictly according to Article 12.
yes. What was the exact constitutional status of India on 26 January 1950? Democratic Republic, Sovereign Democratic Republic, Sovereign Secular Democratic Republic, Sovereign Social Secular Democratic Republic. Answer is Sovereign Democratic Republic. The Sovereign Socialist Secular Democratic Republic by 42nd. Answer is B. A constitutional government means, very important. Think and tell me. Constitutional government. See, constitutional government means the government which will be exercising the power according to the principles of constitution and who are limited by the constitution are called as constitutional government. A representative government of a nation with federal structure, a government whose head enjoys nominal powers, a government whose head enjoys real powers, a government limited by the terms of constitution. That is the beauty of constitutional government. Constitutional government every time talks to control the government, so that there will be no tyranny, arbitrary rule. It is a duty of the constitution to control the tyranny government, to control the arbitrary governments. So, constitutional government is also called as limited government. Dictatorial governments are called as absolute governments. Right to marry 21. Right to marry, Article 21. Which of the following is a fundamental duty provided under Article 51A of the Constitution? What all constitute, or 51A, to promote harmony and the spirit of common brotherhood among all the people of India, protection and empowerment of environment and safeguarding of forest, Article 48, provision for just and human conditions of work, 42, secure a social order for the promotion of welfare of the people is secure a social order. Social order 38. So, this is only fundamental duty. We remembered fundamental duties. Again, we will have a quick revision. Fundamental duties. First one is what? National flag and national anthem. Second is protection of integrity and unity of the nation. Third, protection is protection. Third is common brotherhood. The fourth is public property. Fifth is one word we remembered, no? Only 2 days happened, at least 20 days means okay. Right to forget is a Article 21. Sir, what sir? This is Article 21, I am enforcing it. Next, public property. Next, environment. Next, composite culture. Next, scientific temper. Next, defend the nation called upon. So,
Forest, wildlife.
protection of forest and wildlife. Next, protection of finish. Next, 0 to 6 years. Huh? Next, 6 to 14. Next, 6 to 14. Next. Now we will remember DPSP. Article 36, definition of state. Article 37, justiciable. Very good. Directive principles of state policy are non-justiciable. 38, social order. 39, equal pay for equal work. 40, village panchayat. 41, right to work. 42,
Maternity.
human and maternity. 43, participation of workers in management. 44, uniform civil code. 45, education. 46, welfare of weaker sections. 47, nutritional of children. 48, animal husbandry. 49, wildlife. 49, 50, separation of executive from judiciary. 51, international. Article 12, definition of. 13, laws inconsistent with. Article 14, right to equality. 15, no discrimination on the grounds of. 16, equality in public opportunity. 17, abolition of untouchability. 18, abolition of titles got removed. 19, 6 are there. Speech, association, assembly, movement, residence and profession. Article 20, one cannot be an evidence for himself. He cannot have a double jeopardy. 21, right to life and liberty. 22, preventive detention. 23, child labor. 24, bonded labor. 25, profess, practice, propagate religion. 26, manage religious affairs. 27,
Taxation.
taxing the religion. 28,
Freedom from religious
instructions
instruction.
in the educational institutions which are completely funded by state. 29, conserve, preserve religious minorities and linguistic minorities. 30, educational institutions for religious minorities and linguistic minorities. Article 31, right to property repealed. 32, right to constitutional remedies. 33, extent of fundamental rights to defense and police forces. Restriction of. 34, martial law. 35, Parliament have the power to make laws with respect to fundamental rights. It is not the state legislature, it is the Parliament. Article 35. 36 is definition of state of DPSP. Next question. Protection of wildlife comes under which of the following in the Constitution? Fundamental duties, directive principles of state policy, 7th schedule. 7th schedule, yes. By which 42nd, 5 added no into the concurrent list. In which year? 42nd. 5 were been added into the concurrent list. What are the 5? Weights and measures. Education. Forest and wildlife. Next, more 2. Justice. One more. 5 are there. Online people. Online people, when they are not answering, they are leaving. There is no scope for offline people. They have to sit only. Online people, they can, I don't know all the answers. What is. Mummy, keep TV. Serial is coming. We will watch sometime serial. 7th schedule is also with respect to protection of wildlife. Directive principles? Yes. Which article? Fundamental duties? Yes. So, we select the correct answers given below. C. Next question. With respect to provisions of Simon Commission Indian history. Simon Commission, favorite question for UPSC. I don't know. For every 3 years or 4 years, they will ask Simon Commission. What is Simon Commission? The Simon Commission is mainly to study about Government of India Act of 1919. Government of India Act of 1919 is called as Constitution according to the Government of India Act of 1919. So, to study about this Constitution, Government of India Act of 1919, a body will be constituted within 10 years. Hence, in the year 1927, a body was been constituted which is called as Simon Commission. And what are all recommendations were been given here? The recommendations given are abolition of diarchy. So, Government of India Act of 1919, diarchy is present in center or state? Center or state? State. And diarchy shifted in Government of India Act of 1935 to center. So, in 1919 in provinces, the abolition of diarchy in provinces. extension of responsible government to the provinces, establishment of Federation of British India and princely states, continuation of communal electorates and so on, means increasing it. The British government convened 3 round tables on the recommendation of Simon Commission. Because of this only 3 round table conferences was been held between the British India and Britishers. Abolition of diarchy, yes. Extension of responsible government in the provinces, yes. Abolition of establishment of Federation of British India and princely states. So the answer is, please remember this. Simon Commission recommendations also important. Online people, tell the answer. Consider the following statements about the salient features of Indian Constitution. Dual citizens or single citizenship? How many of the given features are correct? Dual. 2-tier government or 3-tier government? By 73rd Constitutional Amendment Act and 74th Constitutional Amendment Act, we have 3 tiers. See, understand this. If the question is Indian Constitution, remember that any Constitutional Amendment Act happened and which is now enshrined in the Constitution is also called as Indian Constitution. In place of Indian Constitution, if it is original Constitution, then you have to think about January 26th, 1950. If it is Indian Constitution, means new amendments also will be part of. So 73rd is, so 3-tier. 2-tier or 3-tier? Drawn from various 100%. Parliamentary form of government. Answer is yes or no? Only 2. Yes, consider the following pairs regarding federal scheme of polity. We copied from 1935 Government of India Act. 1935, but Weimar Constitution, what we borrowed? Not emergency. It is suspension of fundamental rights at the time of emergency is copied from Weimar Constitution. Concurrent list, we copied from election of members of Rajya Sabha, copied from advisory jurisdiction of Supreme Court, Canada. It is not USA, it is Canada. Supreme Court, independence of Supreme Court, independence of judiciary, we copied from USA. Advisory, which article? 143. How to remember this? Some articles we have to remember, like Ordinance 123. Advisory means government is very close to Supreme Court. So whatever the government want to do, they want to take advices from Supreme Court. Like 143. What is 143? So you have to remember. So the government is in relation with Supreme Court. So whatever the government want to do, compulsory they want to take advice from Supreme Court. If not, Supreme Court will not keep quiet. So hence that is 143. 213, ordinance in the state. 123, 213, state ordinance. This is central ordinance. How many are correct? 2. India is a republic. What does this mean? India is a republic. India could acquire a foreign territory, then it is called a sovereignty, no? That is called as sovereignty. But the question is about republic. Vesting of political authority in the common people, yes. When I am called as republic, when I have the right to decide my own ruler, then I am called as, so vesting of political sovereignty. Absence of any privileged class in the society is also 34. Question number 34. Republic. Privileged sections means mainly dominions, kings. Privileged sections are those. So absence of privileged sections means absence of kings. Absence of kings means what? Common people are rulers. Online, tell the answer. Jasya, Rohit Reddy, Bhargavi. Any doubt, Bhargavi? Which of the following is referred as a guardian of the Indian Constitution? Supreme Court of India. Easy question. Apart from being a federal court, the highest court of appeal is Supreme Court. Guarantor of the fundamental rights. Guardian of the Constitution is Supreme Court. Who among the following were member of the drafting committee? Remember all these things. By heart, we will by heart it. Alladi Krishnaswamy Iyer. Drafting committee means finalizing. Drafting committee, final. Before final, what is called? That is called as draft. General understanding is called as abstract. Alladi Krishnaswamy Iyer. Muhammad Sadullah. N. Gopalaswamy. Ambedkar. Munshi. Mitter. Kaitan fans. You know, Kaitan fans would be there. Table fans, once upon a time, very, very famous. Kaitan, Mitter or Mitter, Munshi, Ambedkar, Gopalaswamy, Muhammad Sadullah. According to me, you will remember this Alladi Krishnaswamy Iyer, Ambedkar you will remember, little bit Gopalaswamy also you will remember. This 4 you have to remember. Who is the 4? Muhammad Sadullah, Munshi, Mitter, Kaitan. Sadaullah, Munshi. At its first meeting, the drafting committee elected by B.R. Ambedkar as its chairman. Who among the following were a member of drafting committee of the Constituent Assembly means Gopalasamy, Ambedkar, Muhammad Sadullah, Bitter. 1. Consider the following statement. The 42nd Constitutional Amendment Act of 1976 brought about changes in the preamble and directive principles. Yes or no?
Yes.
Tell me in preamble, you know, socialist, secular, then DPSP what? If you remember 42nd Constitutional Amendment Act, if any conflict happens between the fundamental rights and directive principle, in DPSP, in order to promote social order, in order to promote equal justice, if it is violating fundamental rights also, it will be valid. Yesterday or day before yesterday I told this. By which Constitutional Amendment Act it added to it? 42nd Constitutional Amendment Act. The 42nd Constitutional Amendment Act added Article 31C to the Constitution. Tell me which is correct, which are, think I didn't give the answer, you only tell. Online people. Incorrect means who is correct? 1. This is correct. Amendment added the Article 31C to the Constitution. It was 25th Constitutional Amendment Act which added 31C. With that seeks that implement of the cannot be challenged on the ground that it contravenes with Article 14, 19 and 31. The 42nd Amendment Act as a mini constitution into changes in the preamble and directive principle. Amendability of the preamble. Preamble can be amended, but basic elements of the constitution present in the preamble cannot be altered by an amendment under Article 368. Yes, constitution can be amended till the basic structure cannot be destroyed. Similarly, preamble also can be amended till it don't touch basic structure. Preamble can be amended by executive order of president? No. Preamble has been amended twice so far. Only once or twice?
Only once.
Only once. So correct answer is?
Incorrect. Only 2.
Only incorrect. Incorrect means? Only 2. Incorrect. Consider the following statements about objective resolutions declared in the Constituent Assembly. My question, objective resolution where happened? What was the discussion happened by objective resolution? Objective resolution is what? Online. Objective resolution means what? Who gave the objective resolution? Yes, objective resolution is given by Jawaharlal Nehru, correct. What is outcome? So in the objective resolution they mentioned that what is going to be in the Constitution. What are there? It declared India as a sovereign, socialist, secular and republic. It envisaged to make the people of India as a source of power and authority of independent India. It envisaged to provide safeguards to minorities, backward and tribal areas and other backward classes. This is correct. According to my knowledge, I know third is correct. So I eliminated incorrect. So incorrect. So this is why? Because 3 is correct. Now you tell me. First one is correct or wrong?
Wrong.
Why?
Sovereign democratic.
They are not that much aggressive. So it is wrong, correct. Second one. It is envisaged to make the people of India as a source of power and authority of independent India.
True.
39. See, this is big words. Sovereign, socialist, secular, republic. If we have a common sense, if they kept socialist and secular, then it would be in original constitution only. So it is not present in the original constitution means obviously it will not be present in objective resolution. It envisaged to make the people of India the source and power of the. So answer is
B.
1 only. Means I want to tell you that if socialist and secular is present in the objective resolution, then compulsory they would be kept in original preamble only. If it is not present in the original preamble means the discussion didn't happen. So answer is which of the following statements regarding exceptions to equality provided under Article 14 of the Constitution? The President is not answerable to any court for the exercise and performance of powers and duties of his office till 3 months from the date of exercise of such power. 3 months, no time. When he is in office, he will be exempted from civil only, not criminal. So only civil. Correct or wrong? Why? Because 42nd Constitutional Amendment Act has provided an immunity with respect to publication of substantially true reports of any proceedings of either House of Parliament. Third, a member of Parliament enjoys immunity in context of anything spoken in Parliament. Fourth, exception of equality. The President enjoys immunity in respect of any act done by him in his personal capacity, but his immunity is not provided to from this both what? 42nd Constitutional Amendment Act has provided an immunity with respect to publication of substantially true reports of any proceedings of either House of Parliament. Tell me answer. If C is correct, then why B is not correct? Original it is there. 42nd Constitutional Amendment Act has provided immunity with respect to publication. Say the original constitution itself is told that whatever is happening in the parliament will be public. That is, it is present in the record, it is present in the record, we will tell. So it is not by the 42nd Constitutional Amendment Act, it is present in the articles of the constitution, in the original constitution. But however, a member of parliament enjoys immunity in context of whatever he, 44th very clearly told. And again 44th it is there in the original, and it told, reiterated in the 44th Constitutional Amendment Act of 1978. Which of the following statements about the part 3 of the constitution is correct? Part 3 means fundamental rights. Incorrect, not correct. Incorrect it is. Now onwards, for every weekly test, whoever answers actively, I will give one chocolate. Mainly few people I will tell in the beginning only. Tell me answer. Last. Then there will be a very big problem. They will not come to class now. Yes. Answer. Which of the following statements about part 3 of the constitution is incorrect? Protection of interests of minorities under Article 29 is not restricted to minorities only and includes the majority sections of society as well. True. It is mentioned section. Any section it is mentioned. Yes. Rights under Article 20 and 21 cannot be suspended under any kind of emergency. True. Incorrect. Article 17 defines untouchability as a practice of social boycott of the few individuals that has historically developed.
Not defined.
Not defined. Not defined. Very good. It is not defined. Not defined. What is written here? Defined. Are available to citizens and not to non-citizens. What are this? 19, 29, 30, 15 and 16. 5 articles. 15, 16, 19, 29, 30. How many of the following are part of right to freedom under fundamental rights? Right to freedom. Right to strike is not a freedom. It is not a fundamental right. Then the country will not work. Select the correct answers using it. Right against bonded labor. Right to elementary education. Right to information is also under Article 19. Right to expression.
Yes.
When I want to express, first I want information. So, how many of the following DPSPs are socialistic principles? You know. How many are socialistic? To promote equal justice and provide free legal aid to the poor. It's a social or Gandhian? Equal justice, social. Equal justice, social only. To make provision for just and human conditions of work. Social. To promote cottage industries on cooperative basis. Gandhi. To promote educational economic interests of SC, ST and other weaker sections. Education and economic interests. Socialistic. Means how many happen? Or Gandhian? Tell me. How many of the following directive principles of socialistic principles? We will see answer. To promote equal justice and provide free legal aid, socialistic. To make provision for just and human conditions, socialistic. Promote cottage industries, Gandhian. To promote the educational and economic interests of SC, ST, other weaker section, this is also. Which one of the following embodies the concept of welfare state and that of a police state? Directive principles of state. DPSP talks about welfare state. Fundamental rights didn't talk about welfare state. Fundamental rights actually is a negative. It talks about rights, but it talks about how to grow. Directive principles of state policy is the best manifesto. There could not be any manifesto better than DPSP. If they follow DPSP, then obviously they will win, according to B.R. Ambedkar. In India, separation of judiciary from the executive is enjoined or enshrined in who among the following describe directive principles of state policy and fundamental rights as the conscience of the constitution?
Austin.
Granville, Austin. Conscience. Noble features, who told? Ambedkar told, noble features. With reference to Indian polity, how many of the following are correct? The 25th Constitutional Amendment Act came to be challenged before the Supreme Court in Kesavananda Bharati case. Article 31C was introduced by the 25th Constitutional Amendment Act, which gave Article 39B precedence over fundamental rights. Article 40 deals with organizing village panchayats. 44 states shall endeavour to safeguard the public property and abjure. So this is wrong. Organizing village panchayat correct. First one came into be challenged. Which year? 1971. The 25th Constitutional Amendment Act made in which year? 1971. So it got cautioned in 1973. Second, this one, second statement introduced by 25th Constitutional Amendment Act, which gave rise to. So answer is only 3. Only this is wrong. The fundamental duties were included in the Constitution with the idea of giving more importance to fundamental rights, curbing subserve and unconstitutional activities, preventing abuse of fundamental rights, giving more power to the executive, curbing subversive and unconstitutional activities like respecting national flag, cherishing the ideas of national freedom fighters, and protecting the public property, women. How many of the following statements are correct? 5th and 6th schedule can be amended by special majority. See, understand this. 5th and 6th schedule means what are present in the 5th and 6th schedule. If I want to add some states into the 6th schedule, how many states are there now in 6th schedule? 4 states are there. AMTM, Assam, Meghalaya, Tripura and Mizoram. How many states are there in 5th schedule? Schedule areas, 10 states are there. What are there? Andhra Pradesh and Telangana, Maharashtra, Gujarat, Madhya Pradesh, Chhattisgarh, Himachal Pradesh, more, Himachal Pradesh, more, Odisha, more, Jharkhand, one more state, I told Chhattisgarh. So, how we have to remember? Remember the map. Once upon a time combined Andhra Pradesh and Telangana. Once upon a time combined Maharashtra and Gujarat. Once upon a time combined Madhya Pradesh and Chhattisgarh. Then tribal state means what? Jharkhand. Tribal state means what? Odisha. Himachal Pradesh. One more? Rajasthan. Gujarat on top. Like map you can remember. These are the 10 states. Number 1, Andhra Pradesh, Telangana, Maharashtra, Gujarat, and Gujarat is added to Rajasthan. Next, Madhya Pradesh and Chhattisgarh. Tribal states are Odisha and Jharkhand, and one is Himachal Pradesh. If we want to add any state, if we want to remove any state, it is simple. Can be amended by simple majority. No. Number of judges Supreme Court are increased with an executive order? No. By a constitutional amendment. Present sanction strength is how much? 33 plus 1. It is not 29. It has been increased by constitutional amendment. So, how many are correct? This is also wrong, no? This is also wrong. This is also wrong. So, answer is 49 is none. How many now? 33 plus 1. Last question. Consider the following statements about the directive principles of state policy. They serve as a crucial test for the performance of the government, 100%.
Yes.
They are intended to fill in the vacuum in Part 3 of the Constitution by providing a political and economic rights. Political and economic rights are social and economic rights. Legislative action is required for its implementation? No. Executive is also sufficient. So, how many are correct?
Only one.
Answer is, we will think, wait. As directive principles of state policy are not automatically enforced by required legislative action for their implementation. Legislative action is required for its implementation. Think and tell me. I am not telling I am correct, think and tell me. Think and finally come to a conclusion. Meghala, sir, in 42nd question, right against bonded labor comes under right against exploitation, right? Then how it is correct under right to freedom? Right to freedom. In right to freedom, how many are there?
19 to 23.
Speech, expression, association, assembly, movement, residence and profession. Meghala, profession. So, profession according to my choice. Bonded labor not according to my choice. So, if I am not working according to my choice and you are forcing me to work, means it is violation of my article 19. Got it, Meghala? No, I didn't answer, I am just asking. That is the reason I told I didn't came to a conclusion. You tell me. So, he is telling that legislative action is compulsory. For example, take an example, 44. Uniform Civil Code. To Uniform Civil Code to be come into action, what is required? Law is required. Now the present government want to make a law with respect to Uniform Civil Code. They are telling that we will make a law for Uniform Civil Code. Why? Because it is already present in the. So, answer is B. As the directive principles of state policy are not automatically enforced by they required legislative action for their implementation. The best and the easy example is Uniform Civil Code. We are demanding for Uniform Civil Code, which cannot be done by executive resolution. There is a need for law. When they make a law, compulsory there is a need for consensus among the people. So, for the consensus among the people, I have to appease whom? Minorities. Hence, it is becoming a tougher task. If it is executive resolution required, then the government can make a executive resolution. So, it takes lot of toil, hard work for us also, for you also. Daily discussion class is a very tough task. We are doing, you should use it, you have to prepare. After class also you have to prepare, before class also you have to prepare. This is high time, January 1st onwards. First you clear prelims, you will get confidence. Leave about mains, I am telling you, don't worry about mains. If you want to be in the field, first you have to experience mains. That is one achievement. I am telling you, if you clear prelims, you got employment. Some or the other institute, some or the other place, you can go and ask for any other job, they will keep you. If you write mains, if you don't clear prelims also, you will feel yourself one point of time you are unfit. If you clear your prelims, some point of time, in India you are in top 13,000 people. So don't overthink about the mains. Mains also will happen. If you want to prepare, you prepare. But the schedule is going properly. You also be. Thank you.